Thank you for the introduction, Pam. Thanks to everyone for being here. I'll try to live up to this tall lectern. I have some notes. All right, so I am genuinely really thrilled and honored to be addressing such an engaged and public interested group on such an auspicious occasion, the celebrating the signing of the U.S. Constitution on September 17, 1787 by 39 brave delegates. I think it's not too untoward, though, to think of Constitution Day as celebrating all of those who participated in the subsequent ratifying conventions in the several states, and all of us sincerely committed to the Constitution's legacy today. In that spirit, I want to put in just a very brief plug for more Constitution Day festivities. They keep going after the day is done. As Pam noted, I'm part of the Kinder Institute on Constitutional Democracy. We're putting on a play. I'm not actually in that play, but it should be a great play. You can see it Thursday, Friday, Saturday, or Sunday afternoon at the Reinsberger Theater, What the Constitution Means to Me. Okay, now for the present, Constitution Day, here and now. It's a great holiday. It's a meaningful holiday. It's not about the merchandise. There's nothing to buy. There are no large inflatable lawn ornaments. At least I haven't seen any yet. Right? There's no stressful meal preparation. There's no getting everyone together around the table to talk in what will inevitably devolve into an argument about politics. Right? Or actually, wait a minute. Maybe there is getting everyone together around the table to talk in what will inevitably devolve into an argument about politics. Although then devolving isn't quite the right word, at least not in the negative sense of degenerating. Devolving, though, does work if we think about shifting power to the people to debate and decide on policies, practices, and institutions that define our political community. Actually, that sort of activity is very fitting for Constitution Day, a very fitting celebration, because that's what the Constitution is all about, or much of it is about, from Article 1, which provides for the election of our representatives and makes the people the primary authors of public policy, to the First Amendment, which protects a robust right to free speech, not to mention the 13th, 14th, 15th, and 19th Amendments that expanded the political community in sorely needed ways and made that debate and discussion much more representative. So in that spirit of robust debate, I'm going to argue that Constitution Day is a great time to reflect on the agency that we the people have to interpret our governing charter, our Constitution. And I want to push back on a tendency in American politics in recent decades across parties and administrations that I think has really eroded that agency. So I will start by flashing back to the summer of 1987, a monumental time for American constitutionalism. One, it was the 200-year anniversary of the writing of the U.S. Constitution, drafted in the summer of 1787, leading up to the day that we're celebrating now. And two, the summer of 1987 gave us the nomination and the infamous confirmation battle of would-be Supreme Court Justice Robert Bork. All right, so July 1, 1987 then, President Ronald Reagan nominates then D.C. Circuit Court Judge Robert Bork to serve as an Associate Supreme Court Justice, to fill the shoes of the retiring moderate, at least by today's standards, Justice Lewis Powell. So that same day, Senator Edward Kennedy of Massachusetts takes the microphone on the Senate floor to warn against what he describes as Robert Bork's America, a land in which women would be forced into back alley abortions, African Americans forced to sit at segregated lunch counters, and rogue police could break down citizens' doors in midnight raids without repercussion. So Kennedy's rhetoric was inflated, but the gist of his allegations made some sense. Bork was committed to an interpretation of the U.S. Constitution in keeping with what he saw as its framers' original intent. It's fair to say that the framers of the 14th Amendment, subsequently held to protect the right to abortion in Roe v. Wade in 1973, were probably not specifically seeking to protect the right to abortion when they passed the 14th Amendment. for the simple reason that when the 14th Amendment was drafted in 1866 and ratified in 1868, and for many decades thereafter, the vast majority of states criminalized abortion. Many states continued to do so until Roe was decided in 1973. So I think there are lots of good reasons to defend that now overturned decision, Roe versus Wade, but it is hard to say that the specific intent of the framers of the 14th Amendment was to protect a fundamental right to abortion. It's also hard to say that the 14th Amendment, the framers of the 14th Amendment, intended to stamp out racial segregation in its entirety. The 14th Amendment contains a ringing equal protection guarantee. No state shall deny anyone equal protection of the laws. But when that amendment was passed, and for many decades thereafter, segregated schools were commonplace. This faced no legal challenges, no major legal challenges that made it to the Supreme Court level, certainly, until the 20th century. Racial discrimination by businesses was also woefully common in the late 19th century. In fact, Congress boldly legislated against it in the 1870s, but the Supreme Court struck down that legislation. It said there's no state action here. There's no room for Congress to act. Remember, the 14th Amendment says no state shall deny anyone equal protection of the laws. And so the court said Congress is overstepping its boundaries by trying to stamp out private discrimination. Private discrimination is not state action. Okay. Recall, Kennedy also suggested that Robert Bork's America is a place where police could break down citizens' doors in midnight raids with abandon. This is likely referring to a hardline originalist view that the Bill of Rights, including the Fourth Amendment's protections against unreasonable search and seizure, apply to the federal government. They limit what the federal government can do, not the states, not state governments, not state police officers. And it's fair to say that when the Constitution was written, it was written to create a federal government and to define and limit its powers, not to create state governments and define and limit their powers. They were already created. It wasn't until Mapp versus Ohio in 1961 that the court started applying the Fourth Amendment and its protection against unreasonable searches and seizures to the states, to state police officers, which are most police officers, since most activities are prohibited at the state level, and to state court trials. Again, most criminal trials. All right, so Senator Kennedy had a point. Bork's legal vision did not include many of the court's landmark rulings, expanding civil rights, the rights of those accused of crimes, and the right to privacy, which ultimately came to encompass the right to abortion. Although, as a judge, Bork wouldn't have recognized it to cover even the right to contraception, which the Warren Court had recognized in 1965. So most Americans, as judged by their elected representatives, did not share Robert Bork's legal vision. He was resoundingly defeated in the Senate. His confirmation lost in the widest margin in history, still of 58 to 42. Bork's rejoinder in 1990 was the New York Times bestseller, The Tempting of America, a book in which he defended his constitutional vision against activist judges, whom he charged with rewriting the Constitution in keeping with their own liberal values. Bork called that constitutional revisionism, where 9 unelected lawyers, the justices, impose their moral and political views, not fairly traceable to the framers' original intent, on an unwitting populace, an unwanting populace. So Bork's attack came from the right. He was an important player in the resurgent conservative movement of the 1970s and the 1980s. He served as President Nixon's Solicitor General. He was appointed, as we know, by Reagan to the DC Circuit, nominated by Reagan for the Supreme Court. Like Nixon and Reagan then, Bork had it out for those who he saw as activist liberal judges, foisting their views and values on the American people. He took particular aim at the decisions of the liberal Warren Court of the late 1950s and the 1960s. But then ironically, the Rehnquist Court, the conservatizing court that Bork would have joined had he been confirmed, led by the staunch conservative William Rehnquist, another Reagan appointee, was even more activist. By the numbers, the Rehnquist Court of the 1990s and the early 2000s struck down more federal laws than the Warren Court. Actually, it struck down more federal laws than any court in American history. It also struck down its fair share of state laws. The Rehnquist Court rivaled the Warren Court on that front. And in striking down these laws at both the state and federal levels, these are important laws in significant areas like political redistricting, environmental protection, campaign finance reform, affirmative action. At the federal level, the Rehnquist Court struck down portions of really landmark legislation, including the Violence Against Women Act, the Americans with Disabilities Act, and the Religious Freedom Restoration Act. So these are big deals. On the Roberts Court, our current Chief Justice Roberts, who took the bench, the highest bench in 2005, we've really seen this boldness continue. We're all familiar with Citizens United versus Federal Election Commission, but I have to mention it, in which the court strikes down bipartisan campaign finance reform legislation. Shelby County versus Holder, another bold decision from 2013, in which the court struck down longstanding voting rights protections under the Voting Rights Act of 1965. And a series of cases from 2008 to 2022 or so, the court struck down state and local gun safety laws based on a previously unrecognized individual right to bear arms. These are bold decisions. Since 2022, there have been more. The court struck down major regulatory efforts to limit carbon emissions, to protect wetlands, and to forgive student loans, not to mention invalidating race-based affirmative action in college admissions. And there are more decisions. So before we go any further, I wanted to update Bork's title for our time. His book is The Tempting of America. The title of my talk is The Tempting of America, Right and Left. Because judicial activism is really a bipartisan affair. It's shown itself over the decades to be. Both the right and the left have been tempted to rely on the judiciary to achieve policy gains that they either couldn't achieve through the political process or they didn't want to take accountability for achieving through the political process. Judicial activism then goes in both directions, right and left. On the other hand, what that means about judicial power, at least over the past 3/4 of a century, is that it's only gone in one direction, and that direction is up. From what's often called the rights revolution of the Warren Court through the conservative rights revolution of the Rehnquist and Roberts courts. By the way, in between, we had the Burger Court. Many expected President Nixon's 1969 pick for Chief Justice, Warren Burger, to rein in the Warren Court. That's Warren Burger reigning in Earl Warren. It always confuses me, but either way, this reining in did not happen. What we get from the Burger Court is a full-blown right to abortion in 1973. Burger signed on to that opinion. We get an expansion of equal protection doctrine to cover sex discrimination. We get cutbacks of affirmative action. We get bold expansions of the First Amendment to cover money as political speech. That's really the genesis of that doctrine back on the Burger Court. And of course, the Burger Court basically compels President Nixon to resign when it says that he must turn over the Watergate tapes. So whether we like some or none or all of these decisions, we've got a clear trend line in terms of judicial power, and it's on the up and up through the decades. Now, I wanted to come back to our current constitutional moment, which many are calling a constitutional crisis. We have an emboldened judiciary, as I've just been describing, but we also have an emboldened executive who's issued an unprecedented number of executive orders and an array of bold foreign policy initiatives, all which are seeking to move the law in aggressive new ways. For instance, just to name a few initiatives, we have the redefining of birthright citizenship, we have drastically cutting federal agencies and firing or laying off federal employees, freezing federal grants and loans, imposing widespread tariffs, implementing immigration raids, and carrying out expedited deportations. So meanwhile, Congress has been largely inert, in most cases neither restraining or ratifying executive action. This leaves us in a strange place. For those who oppose many of the current administration's policies, founded on its novel constitutional and legal interpretations, we might say an emboldened judiciary is just what the doctor ordered. We might want to put our hopes in courts. We might want to put our advocacy efforts and dollars toward litigation campaigns, hoping courts will restore the fair and impartial rule of law. For those who would defend the administration's policies, we might also look to the court. Maybe the court also seems like the answer. Maybe the administration is onto something with its frequent appeals to the court for emergency relief. Maybe judicial decisions are the best way to shore up support for controversial actions, to bring some bipartisan legitimacy to the administration's actions. Maybe if the court says what the administration is doing is constitutional, that will settle it. We'll let those questions hang, or those maybes hang, but I do think one thing is clear. The court will have ample opportunity to weigh in on all of these controversial matters, because in addition to the administration's own emergency appeals, there have been hundreds of lawsuits filed against administrative policies to date. The court will have ample opportunity to weigh in. Just around the corner, we have hearings on the legality of President Trump's sweeping tariffs. We can also expect the Supreme Court in the coming term to weigh in on the termination of legal protections for migrants in a variety of programs, the summary deportation of undocumented immigrants, firings of agency officials, ending birthright citizenship, and much more. So should we wait for these rulings with bated breath? Is that too easy of a question? Should we look to courts to lead the charge with answers to these pressing constitutional and legal policy questions? In this time many are calling a constitutional crisis, should we put our hopes in courts to bring stability and civility and good faith back to public life? I think not. And the reason is drawing on Yale law professor Jack Balkin's theory of constitutional rot. Jack Balkin says that underneath or underlying our loss of these good things, our stability and civility and good faith in public life, is a severe case of constitutional rot. That's the deep problem here. And unfortunately, it makes it more likely that courts will be part of our problems than part of their solution. I'll get back to that in a minute. But first, I want to describe constitutional rot. So this is a situation in which government becomes both less small d democratic and less small r Republican. So in other words, government is less responsive to the people and it's less representative of the popular will. That's less small d democratic. Government is also less committed to the public good and becomes more beholden to special interests. That's less small r Republican, Republican coming from the res publica, the public thing. So we have this new kind of dispiriting government. It's underwhelming, it's less representative, it's less responsive, it's more beholden to special interests. What does that feel like on the ground? Well, it feels very familiar. The telltale signs are heightened polarization, heightened income and wealth inequality, and a loss of trust in all areas of political and institutional life. So the public loses trust in government, the parties lose trust in each other, and people lose trust in our major social institutions like media, science, and academia. So in times like these, disaffected, neglected, and distrustful people turn, or may turn, if not to demagogues, to the courts, hoping for some semblance of neutral and reasonable governments, or fairness and impartiality. We know that demagogues will only flatter the people while base seek power for their own gain. But it's not as clear that courts are unlikely to set things right either. Courts are unlikely to bring back some sort of neutral and impartial public rule. And that's for several important reasons. On a basic level, courts depend on social trust and shared norms. We go into a lawsuit claiming we should win the lawsuit, not because we're better or stronger or more good-looking, not because our arguments are more interesting, or even because we're proposing better forward-looking policy. Right? We claim that we should win the lawsuit because we're right, because the law gives us a right to win. It's a pre-existing right. We claim that we should be vindicated based on pre-existing principles that already govern, that we already agreed to. So even if our claim is novel in the case and the text of the law is pretty vague or open-ended, as most of the Constitution and much statutory law is, we still say we have a right to win, because reasoning from law's principles, tracing the rational implications of those principles, drawing out their purposes, we have a right to win. But of course, law's broad principles like liberty, equality, those important principles enshrined in our Constitution, fundamental rights, freedom of speech, those don't apply themselves, let alone to contemporary contexts. That application takes interpretive work. Originalism is one way to guide that work. But even originalists acknowledge that discerning and applying the original meaning of the law is not always an easy, self-executing task. It requires interpretation and judgment. So then what makes an interpretation good? What makes a judgment right? Clearly, there's no answer key. This is a right judgment, this is a wrong judgment. It doesn't work that way. My suggestion is that good and right interpretations and judgments tend to be those, particularly when we're dealing with the open-ended provisions of the Constitution and vague or open-textured provisions of many statutes, good and right interpretations or judgments tend to be those that we can get others on board with. Not in a crude pragmatic sense, but that we can get others on board with as faithful to and faithfully carrying forward our basic constitutional commitments and tradition. It's what makes an interpretation good or right. So even though lawsuits are adversarial, shared norms and social trust do a lot of important work. Because at base, we do have to make a case based on appeals to shared purposes, principles that unite us, traditions and aspirations that we agree to, that we agree on. The problem is, though, in times of advanced constitutional rot, shared purposes and traditions and aspirations seem few and far between. Increasing polarization and inequality and this broad loss of trust, these things erode the shared understandings that give meaning to our constitutional and legal commitments. So what counts as democracy? What about equality? Which rights are fundamental? Which groups suffer discrimination and which groups need protection? In times of constitutional rot, these things become not just contested around the edges, but really at the core. So does protecting the integrity of democracy mean tightening voter requirements and requiring proof of citizenship to vote? Or does it mean lowering barriers to voting? For instance, by expanding mail-in balloting, by making Election Day a national holiday? Those are two very different visions, but they both coexist. We can see this in other areas too. Our women, our racialized minorities, our LGBTQ people in need of state protection. Or our conservative Christians increasingly marginalized in public life, our unborn fetuses most in need of state protection, the most vulnerable population. It depends on who you ask, and our answers surely track our partisan affiliations. So in times like these, I think we're tempted to turn to courts. We like to think that courts will neutrally uphold the ground rules of democracy when politicians won't. They'll boldly stand up for fundamental rights, particularly the fundamental rights of the marginalized, when politicians won't. But democracy, fundamental rights, and which groups are marginalized aren't givens. They require interpretation, and in times of advanced constitutional rot, those interpretations are polarized too. That polarization inevitably comes to the courts, and especially it comes to the Supreme Court because of how justices are selected. It's important to note, it's not my claim that the justices themselves are particularly corrupt. Rather, they're products of our political climate and of the broader process. When parties are so opposed to each other and internally fractious that they can't get anything done, that puts a lot of pressure on courts as our preeminent national policymakers. Increasingly, politicians look to judicial decisions as the ultimate policy prizes. Unsurprisingly then, presidential campaigns these days are filled with promises about Supreme Court appointments. It's really a very contemporary phenomenon. Naturally, justices and their rulings then increasingly reflect the polarization that put them into power. The promises that they're supposed to fulfill, that presidents themselves didn't have to, because their justices would. So on the other hand, the court does have some incentive to maintain its legitimacy as an independent institution. Many have interpreted Chief Justice John Roberts this way, as an institutionalist. And that incentive to maintain legitimacy as an independent institution does lead the court, say, to want to push back, maybe rein in executive overreach, at least in some circumstances. The problem there, though, tends to be more practical. President Andrew Jackson famously said, or at least reputedly said, after the Supreme Court handed down a decision he didn't like, Chief Justice John Marshall has made his decision, now let him enforce it. So Chief Justice John Marshall couldn't enforce the court's decision, keeping the Cherokee on their ancestral lands in Georgia. Georgia forced the Cherokee off their lands with the help of President Jackson and a willing Congress, who passed the Indian Removal Act of 1830. All right, in times of advanced constitutional rot, though, even that is unlikely to happen. I don't mean to endorse the Indian Removal Act, but I do mean to note that Congress and Jackson worked together. They worked together to pass aggressive legislation opening up vast areas of land for white settlement. In times of advanced constitutional rot, the president tends to act aggressively alone, while Congress sits on the sidelines. That puts even the most upstanding court in a difficult spot, because it means that most constitutional questions that reach the court have to do with the separation of powers. For instance, does the president have power under the International Emergency Economic Powers Act, passed by Congress in 1977? This is totally hypothetical, to impose sweeping tariffs? Right? Did Congress give him that power? Could Congress give him that power? Does the president have power under the Alien Enemies Act to summarily deport hundreds of migrants? Did Congress give him the power, and could it? Does the president have power to slash administrative agencies that Congress created by statute, or to revoke funding that Congress already appropriated to those agencies? All these questions center on the balance of power between Congress and the executive. So the court can say that the president overstepped his bounds. If it does have that initiative, it can say that the executive is treading on congressional power, congressional prerogatives. But if Congress doesn't want that power or doesn't use it, then the court's rulings can make a stir, but ultimately, practically, they fall flat. They don't do much. So that's a separation of powers conundrum. But it's also related to an important point about the collaboration of powers. In contentious cases, even if the court leads the way, as it did in Brown versus Board of Education in 1954 and the follow-on desegregation cases, the court is most successful when it has the support of another branch of government. So, for instance, the Warren Court's bold civil rights decisions were crucially supported by Congress. They were supported by a Congress willing to pass the Civil Rights Act of 1964 and the Voting Rights Act of 1965. In fact, really interesting political science work has shown that desegregation in the South was really not widespread after Brown versus Board of Education. It was widespread after Congress threatened to cut funding to public schools as part of the Civil Rights Act of 1964 if they didn't integrate. So we have a partnership. Maybe the court led the way in insisting that separate but equal is not equal, but Congress then was there at the court's back. And we had a president willing to send in the National Guard to insist that the court's desegregation orders were implemented. So today, that level of collaboration across different governing institutions and actors, all broadly committed to the same vision of good and just public policy, seems far-fetched, right? That is the bad news. Constitutional rot creates deep interpretive divides and serious practical problems that make it hard for the judiciary to right a sinking constitutional ship. So while that is the bad news, there is also good news, although it requires taking a longer view and it requires a bigger lift. According to Balkin, this is the Yale law professor who gave us the idea of constitutional rot is part of a broader cycle. It's part of a cycle that runs from constitutional rot to constitutional renewal. So, according to Balkin, we've had rotten times before. but we will rise again. Rotten times leading up to the Civil War, rotten times leading up to the Gilded Age, rotten times after the Gilded Age, when there were robber barons and masses toiling in their factories and ultimately plunging us into the Great Depression in the 1930s. Those were rotten times. But we emerged from those rotten times with Reconstruction after the Civil War and with the Progressive Era and the New Deal after the Gilded Age. In both cases, though, it's notable that courts were not only of little help, they were a significant part of the problem. Chief Justice Taney's Dred Scott decision played a big part in catalyzing the Civil War by declaring African Americans incapable of citizenship and declaring Congress incapable of banning slavery in the territories. In the lead up to the New Deal, the court struck down dozens of laws protecting workers in mines and factories, including protecting children toiling in mines and factories or attempting to get them out of there. Child labor laws. The court struck these down. It struck down then regulations needed to bring the country out of economic collapse in the Great Depression. There was an epic battle between the court and the political branches. Ultimately, things did change. That was not so much thanks to courts. It was thanks to activated citizens who, on their own and through associations like trade organizations, labor unions, local clubs, churches, and public interested groups like the League of Women Voters, rose up and made their voices heard. They didn't look to courts, at least not solely. They voted and protested and lobbied and campaigned for reform, drawing on the best parts of our constitutional tradition. They fought to enhance equality, curb corporate greed, and promote public goods. So in other words, they took aim at the root causes of constitutional rot: the polarization, the inequality, the loss of trust in government and public things that obscure shared purposes, traditions, and aspirations, and that make finding common ground seem impossible. That's hard and uncertain work. It's daunting even saying it as I stand up here. It isn't as tempting as turning to courts to give us the answers to the day's pressing controversies, but I think in the long run, history shows that it's a much stronger strategy. So on Constitution Day, my message is to remember what generations of American patriots have known. But in more recent decades, we've started forgetting. Courts are not the natural and necessary deciders of all our constitutional and legal debates. In fact, if we want them to be effective, they can't be. Because legal arguments depend on shared purposes, on sincere public interestedness, on common understandings. Courts can't manufacture those for us. We, the people, have to build them ourselves. The end.